We are going to start it off with Matt Bellinger from Benecounsel. He's a lawyer that I met many years ago, has been a phenomenal resource for all kinds of matters, and brings a very real world experience. He himself is a parent of an adult child on the autism spectrum, so he really understands the challenges faced by young adults with disabilities. Matt, take it away.
Thanks, Marilyn. So today we're going to talk a little bit about the number of things that kind of all happen about the same time when an adult, soon to be adult child with disabilities turning 18. Lots of things change it. My experience and in working with clients, we spend so much time as parents learning the special education realm. How to get an IEP, how to get the most out of the IEP, how to get the most out of the therapies and things like that in school. And then around the time our son or daughter's turning 17 and 18-ish time frame, we realize there's a whole host of different things we have to be worried about and have to consider. Guardianship, powers of attorney. Most of the time our children will become eligible for SSI and Medicaid and things like that. And then you start talking about special needs trusts and all these different things. And I remember even before my daughter, she was like 10, we met with an investment advisor who was talking to us about special needs trusts. And I was just overwhelmed. I wasn't even an attorney at the time, and certainly wasn't doing this kind of work. And we set it aside for years. And I felt so guilty every time I'd see that package of information, because when he told us we had to get an attorney and it would cost, X amount of dollars for that to just do the trust, and it's like, oh my God. So there's a lot of things to consider as parents of a child with a disability, especially when they're turning 18, and we're gonna kind of go through those. So can I share my screen? I'm gonna try it. Share, yes, all right. So that way you don't have to just look at me while we're doing this. And now I'm not going to necessarily talk specifically to the specific things that are on the slides. I really don't want to just read from the slides. I'm going to try my best not to do that. But today we're going to talk about guardianships and the alternatives, disability benefits, and special needs trusts. Let's start with capacity, actually. Well, actually, not capacity, but these are the things we talked about when your child turns 18. They have the legal right to make their own decisions, even if they can't or even if they need help. And in fact, an 18-year-old, an adult, is the only person that has the legal authority to do that for themselves. So things get more difficult, harder to make medical appointments, harder to make medical decisions, harder to make decisions on IEP meetings. If your son or daughter's 18 and they're the ones that have to sign off on the IEP. And so we'll talk about ways that the legal tools that I've got in my legal toolbox to help parents at this juncture. Also talk about SSI and Medicaid, although many of you may be familiar with Medicaid. We'll talk about that. And some of the other disability benefits, just so you have an idea of what to expect down the road. And definitely talk about the countable resource limits for those. It's $2,000, but that's also the segue into talking about special needs trust, because main purpose, I would say, of a special needs trust is to protect a beneficiary of SSI or Medicaid, protect their eligibility for those benefits, and at the same time be able to leave them an inheritance for their benefit. So let's start with capacity. It's actually not defined. What's defined in the Virginia Code is incapacity. And basically it's when an adult or soon to be adult has the inability to receive and evaluate information or respond to people, and it results in their inability to be able to make decisions for themselves. It actually says poor judgment alone isn't considered sufficient evidence. So get a chuckle. It doesn't come up as much as it used to, but there's a story of the elderly grandmother who's got a much younger lover, and they're going and spending all of her money and doing things. And, is that, for some people may think that that's poor judgment, but in that scenario, the case I don't know if it's a real case or not, but talks about how she knew exactly what she's doing. It's just her money and she wants to spend it while she's living and have fun. So is it poor judgment? Is it? But it's definitely not evidence of incapacity. That really doesn't apply. That kind of scenario apply to a young person, young adult with disability. Really talking about whether or not they're able to receive the information and communicate their understanding enough of a medical procedure and things like that. So, although the title of the presentation is Guardianship and the Alternatives, I moved this slide up so that we talk about the alternatives to a guardianship first. First is because a guardianship is so restrictive. Under a guardianship, a person loses rights. So we should look at the alternatives first. And in fact, I do. When I meet with families, we talk about the alternatives to a guardianship before we talk about guardianship. Another reason is that the Virginia General Assembly has been making steadily every year since 2020, been making changes to the Virginia Code. One of the more recent ones is that in a guardianship process, once a petition's been filed, the court and the guardian ad litem who's appointed, and we'll talk more about that when we talk about guardianship, are supposed to take a long, hard look to see whether a less restrictive alternative to the guardianship would work, i.e. powers of attorney. So this is where we start. So let's start with what's the capacity to sign these documents. The capacity in Virginia to sign a power of attorney is that a person needs to understand the authority that they're giving to their agent. They don't have to be able to make all those hard decisions. They don't have to be able to explain the power of attorney and tell me how it is, and or even be able to read it all. They really just need to be able to understand the authority that they're giving to somebody. And it's up to the attorney working with their client to determine whether their client has the capacity to sign that power of attorney. And since I work solely with adult children with disabilities and their families, I like to find that level of capacity whenever possible. Otherwise, we'd be doing a lot more guardianships. We have, my wife and I have powers of attorney for our daughter, and I can tell you that they work really well. But they're not right for everybody. Every situation, every young man or woman with a disability is different. So it's specific to the person and the family situation as to whether or not an alternative of guardianship is the way to go. But that's where I start. So there's a durable general power of attorney, which is basically for finances and contracts, Medicaid applications. In fact, Medicaid waiver services, the portion when you meet to figure out the services that will be available for the year, that would arguably, in my opinion, be under the durable general power of attorney. And it has a whole number of different things that you can use it for. There's a medical power of attorney, also known as an advance directive for healthcare in Virginia. Now, technically, an advance directive in Virginia also includes the end of life decision making, hence the term advance directives. These are what I would like to have happen when I'm close to dying. I do not include those in the medical power of attorney that I write in our template for young adults, because first of all, I don't want to have that conversation with a young adult. Nor do I actually think that any 18-year-old really is going to understand that, even typically developing ones. Some will, but not young men and women with disabilities. So the medical power of attorney, I'm going to call it that for the rest of this, that we write for young adults is basically, here's my agent. The agent has the authority to do these things for me. Some of the things that a medical power of attorney, when it's really useful for, is making medical appointments, filling prescriptions. It allows doctors to talk to parents or to the agents because it has a HIPAA release. And it works really well. When my daughter turned 18, we relied on that quite a bit to be making appointments for her and doing things for her. Now she's 26, she makes about half of her medical appointments, especially the ones where you leave the dentist's office and you got your teeth cleaned and they say, do you want to make the next one? She can absolutely look at her schedule and say, yeah, I want to do for this date. and put it on her calendar in her iPhone. There's also a power of attorney for education, and that's specifically for IEP meetings. It does not work after a student ages out of IDEA, ages out of special education at 22. And another alternative to guardianship, actually, it's not an alternative to guardianship, it's an alternative to a conservatorship, is being a representative payee for the Social Security Administration. Social Security Administration is a federal agency. Most of the benefits it overseeing, SSI and SSD, are federal benefits. So the Social Security Administration doesn't use guardianships or powers of attorney. When a beneficiary can't manage their own finances, the Social Security Administration will instead appoint a representative payee. So these are the alternatives to a guardianship. And when I meet with families, we talk about that first. And when I'm evaluating whether or not a person has the capacity to sign this, we look at, how they're doing in school. In fact, I've been working on it more recently. So I can kind of put it in a form for me to use or other attorneys to use. Communication skills are a big one. So I believe every young adult, young person with a disability has the ability to understand a lot more than they can communicate. Even the high functioning, even my daughter, who communicates fairly well. But in some cases, if a young man or woman is nonverbal or minimally verbal, then their lack of the ability to communicate their understanding of the authority that they're giving their agent often precludes me from doing a power of attorney. In those cases, we do guardianships. Although I have done powers of attorney for young men and women who are nonverbal, in those cases, they were able to communicate through an electronic device. Now, just because I believe a person has the power, capacity to sign a power of attorney doesn't necessarily mean that that's the best way to go, because there are some certain situations that we've run into that we've identified where guardianship might make more sense. And one of those is when a person has severe medical issues, medical challenges. For example, a number of years ago, working with family, daughter had Down syndrome, had numerous, 3, I think, heart surgeries, and did not want to go back to the hospital, did not want to do that again, did not want to have to do that. And kind of afraid that she would refuse care, wouldn't want to go, and they would have to, that's not the time to be waiving a power of attorney and saying, she signed this power of attorney, I get to help make decisions. So we did a guardianship in that case so that we'd have a clear-cut decision maker. Because that's the thing, under a power of attorney, any of these, the young man or woman does not lose the rights to make their own decisions, which is a good thing. We don't want to take away a person's rights if we don't have to. So if they work and they can make their own decisions with help, and power of attorney is going to work, then that's the way to go. But severe medical issues is one. Behavioral challenges, unfortunately, although a medical power of attorney can include special powers to be able to get inpatient mental health treatments for somebody, even against their will, for a period of 10 days. Even though that has that ability, it's really hard to then make the decisions for the follow-up care that is so often necessary. What happens is it works. You can use the power of attorney. You can get them in to the inpatient, like the REACH facility, or to the hospital, to the emergency room, get them admitted. And after about 3 or 4 days, when they've stabilized and they're back on medications, the hospital wants to discharge. And that's where the problem, in my opinion, with a medical power of attorney in those cases for severe mental health runs into an issue, because parents under the power of attorney don't have the legal authority to say, no, stop, we're going to try to find the follow-on care, and I want you to transfer to this program, because the young man or woman has the ability to sign themselves out. And even if they're willing to go to that other care, often the hospital really looking to discharge. Unfortunately, that's just my experience in some cases, so. I'm leaning more in those cases to doing guardianships. And now we're working on perhaps doing limited guardianships, because when a person with a severe mental health issue is on their medication and they're doing well, they typically have capacity. And when they're not, they don't. So those are more challenging. So even though power of attorney, we start there, even though the person may have capacity, that doesn't necessarily mean the end of the discussion. If they don't have the capacity to sign a power of attorney, the only other legal tool that I have to use is guardianship. So guardianship in Virginia it's a procedure in the circuit court. Starts when we file a petition asking the judge to appoint a guardian or co-guardian. So more than one person can be guardian at the same time. In the petition, we include whether or not they have signed a power of attorney. So that's something that's a factor that the court's going to consider. If they have, that doesn't mean we can't do it. And typically when those cases when I'm filing a petition on those cases, we will lay it out, say, judge, reason we're filing a guardianship is we tried the power of attorney route and it didn't work for these reasons. As part of the process, the court appoints a guardian ad litem, which is another attorney that's trained to work with adults that are allegedly incapacitated. Guardian ad litem's job is to be a neutral third party, to meet with everyone, meet the person, look at the medical reports, look at the IEP, and then report back to the judge whether the person needs a guardian and whether the proposed guardians are suitable. And in cases where, my typical case where we're filing a petition for guardianship where the parents are the proposed guardians and the young adult or soon to be young adult is the respondent, an incapacitated person, the guardian ad litem's report and investigation is very, very, very straightforward. In fact, the whole case is straightforward. In fact, so much so that the hearing itself that we have once all the courts, all the forms have been filed, petitions and notices and so forth, are short, 2 to 5 minutes. It's no evidence necessarily put on. I just proffer evidence, the judge accepts it. So an uncontested guardianship for a young adult with disabilities is very straightforward. Now, in a guardianship, though, they'll lose the rights. They'll lose the rights to make their own medical decisions, the right to make decisions about where to live, and the rights to make their own educational decisions. And I would argue that if they can make all of those decisions, they probably don't need a guardian. Unless we're talking about mental health issues. Well, when they're having a severe mental health problem, they can't make those decisions. So. Also lose the right to drive, the right to vote, although those are two rights that I can often get a judge to allow a young person to retain, especially if they're showing the ability to drive or they've gotten their learner's permit. Although the right to drive, though, if they haven't reached that stage, most judges will err on the side of caution and say, well, no, they can't do it now. Nobody thinks they can do it right now. So why don't we say no to that? Because the thing is you can always go back in and restore rights at a later date. And I've done that for a number of cases for young men and women who, when they got the guardianship, weren't able to drive, but then several years later, showing the capacity to do that. And judges are more than willing to, they're eager, they're happy to sign an order restoring the right to drive. Lose the right to own a firearm, the right to marry without permission of the guardian, and the right to sign contracts. So in many ways, doing a guardianship for a young adult is like resetting the parent-adult-child relationship back to parent-child, because when child is 17 and a half, they don't have any of those rights. When they're 18, they have the rights. But in the case where they can't exercise those rights because of their incapacity, because of their disability, guardianship is basically restoring it as if they were 17 and a half again. And now guardianship's over the person. We talked about the kinds of decisions a guardian makes for a person. Conservatorship is on the financial side. And I can tell you though, I don't do very many and I don't recommend it. In most cases, we don't need to because the young adult has no assets. Their primary source of income is typically SSI. And we have already talked about, there's an alternative to a conservatorship. That's the representative payee appointment by the Social Security Administration. So I don't do very many conservatorships. Conservatorships that I do are when a person that relies on SSI, Medicaid waiver services gets a direct inheritance or gets a injury settlement. Then we often have to do a conservatorship or add a conservatorship to the guardianship so that there is somebody, the conservator, that has the legal authority to move that money into a type of trust that restores their eligibility or maintains their eligibility for those benefits. But I can tell you then, as soon as we got that into the trust, we end the conservatorship. Why? It comes with reportings to the Commissioner of Accounts. It's like being an endless probate. And if you don't need it, I really typically don't like keeping it open. Now, there are some commissioners that are really good about letting the conservator, when there's nothing under management, not file reports anymore. They're not all that good. Not all of them feel that they have that capacity. And I think at first I thought it was the Commissioner of Accounts. I'm like, well, so-and-so in RICO does it. Why can't you do it? Thinking that, not saying it to them. Oh, no, I don't want to do that. But I've come to find out it also depends on the circuit court judges. What are their expectations? Do they allow the Commissioner of Accounts that much leeway? So conservatorships, we do them if we have to. So, and you can do both at the same time if you need to. The earliest you can file a guardianship petition is 6 months prior to a person's 18th birthday. So the time to really be thinking about this, talking to an attorney and to get information, to get advice as to which way to go is about, when your son or daughter is turning 17 and a half. There's no difference in the process, whether or not you start before 18 or if the hearing's before 18. I hear a lot of people being given information is like, oh, you have to get it done before 18, otherwise it's so hard. There's no difference. In fact, the process is the same no matter if you're 18 or 85. The guardianship for a 17-and-a-half-year-old is going to look exactly the same as a guardianship of an 85-year-old if they both have no assets. Because the conservatorship, that's the one that's really a lot more involved when a person has assets. I don't do those. So for example, if grandpa needs a conservator because he's no longer able to manage his finances and he has lots of money, those can actually become quite involved cases where family members are gonna fight over who's gonna be the conservator because, well, money has a tendency to do things to people, give them different motivations, but that's besides the point. Guardianship, earliest we can file is 17-and-a-half. Takes about 4 months to get one in place, 4 to 5 months, 3 to 5 months, someplace in there. A lot of that time though was waiting for the court to get the order to us, appointing the guardian ad litem, maybe 2 weeks there. And then once we have everything, setting the case for a hearing, I like to give guardians ad litem about 6 to 8 weeks in order to do their reports, meet with clients, and so that they have their report done in time for the hearing. Only time, and I haven't had to do this in a while, that we've rushed one is when a young man or woman is receiving inpatient mental health care and they're about to turn 18. Because at 18, they have the rights to make their own decisions and they can sign themselves out. And I haven't, like I said, haven't had a case like that for years. I hope we don't ever have one again. But that's what I would try to do everything I can to get it done as fast as possible. There is no emergency guardianship in Virginia. In fact, the Virginia General Assembly has been adding each year, like I said, more and more requirements and what need to be in the petition, what needs to be in the order, what does the guardian ad litem need to look at, and it's actually making it more and more challenging. I was gonna say difficult. We can still get guardianships. If a person needs a guardianship, they get a guardianship, but there's more and more things that need to be in the petition and things that need to be taken a look at. So much so that I do worry a little bit that there'll be less attorneys doing guardianships, because I do believe now that it's probably outside the realm for a general practitioner to do a guardianship if they've never done one before. Especially depends on the jurisdiction too. Some jurisdictions like Fairfax and Virginia Beach are really, really sticklers to it. They should all be, but some are more so than others. So you need to get off onto that.
Hey, Matt, we had a
Yes.
question that I missed for the last area. It says, so if the individual doesn't agree with the person that has the power of attorney, then who makes the final decision?
Oh, the individual. So when a person signs a power of attorney, they don't lose the rights to make their own decisions. And what they're doing, that's a really good question. So when anybody signs a power of attorney, whether it's a young adult or if it's an elderly person or like myself, well, I'm elderly now, signs a power of attorney as part of your state planning, saying if I can no longer make my own medical decisions and decisions about my finances, I appoint my wife. And if she can't do it, then it's my brother. And that if he can't do it, then it's my son. Well, I don't lose the rights under that to make my own decisions. And in fact, what I'm actually doing is appointing an agent. There's a fiduciary relationships there, an agency relationship where they're doing it for me. So, because I can't or because I don't want to. Same kind of relationship, say, for example, when a famous person, a rich person, or an athlete, or Taylor Swift signs a Taylor Swift, I'm sure, doesn't make her own medical appointments. She has an agent do that, and I'm absolutely positive that in there someplace is a medical power of attorney allowing her agent to do that. Probably spells out the limits of their power. And she can at any time override it. So that is something too when we're thinking about whether a power of attorney is going to work. Is what's the likelihood that the young man or woman may, I've never had any of them revoke a power of attorney. They can certainly do that. But how much resistance are they to decisions? If a doctor's saying this and their parents are saying that this needs to happen, how much are they willing to go along with that? I don't have problems with that either, except when it comes to mental health issues and taking medication. That seems to be a stickler a lot. Now, going over to guardianship, that's a segue. So in a power of attorney, the person signing the power of attorney has the ultimate say. In a guardianship, it's the guardian has the ultimate say. However, in a guardianship, I kind of laid out what it's like for an uncontested guardianship. The person that is allegedly incapacitated has the right to an attorney. If they ask for one, the judge will appoint one for them. And if they don't have finances to do it. If other family members don't agree with who is filing for the guardianship, they can get involved. So I don't take these cases. I try to actively avoid them. But when two ex-spouses don't agree as to who should be the guardian, they can contest it. And when you do that, you get into basically a trial. It can be a 2-day trial where evidence is put on with documents and testimony and so forth. So a contested guardianship is quite more involved than an uncontested guardianship. And I bring that up because the person with a disability can also contest it by asking for an attorney. That attorney then would try to represent them as best as possible. And there are rules and procedures set up that kind of guide an attorney as how to represent a person if they have diminished capacity. And finally, there's a recent 2024 change to the Virginia Code on that same subject. We talked about powers of attorney, who makes the decision. We talked about guardians and who makes the decision, and how a person has the right to an attorney be appointed for them if they can't afford it. And they just changed it so that at any point, if the person under a guardianship wants the judge to consider making a change to it, or wants to change their guardians, or wants to do something, they don't have to have an attorney. It's just added to the Virginia code. They can send an informal writing to the court. All new guardianship orders are required to put in the address of the court and the email of the court so that they can do that. So simply sending an email to whatever email is that is going to be listed for this particular court from the incapacitated person is enough for the judge to consider whether or not there's good cause to open up the case again. That's one of the more recent, that is actually just went into effect July 1st. I've been working with Fairfax. I've got a hearing on Friday to make sure I get the right email to put in the order. So a person's rights are pretty well protected in a guardianship case. So when I meet with clients, we take a consideration of all that. We try to figure out what's the best way to go. And in some cases now, I think back here, we talked about this may be limited. I can tell you that until last week, I'd never done a limited guardianship order. And that's because it's really hard to figure out how to limit the authority of the guardian in such a fashion that the order still works. It's not like a conservatorship where it's pretty, you can limit a conservatorship. Saying, for example, grandpa gets to manage these accounts because this is his bank account and we're going to keep $8,000 in it, whatever. So it's not like we can really do a lot of harm, but all these other accounts, we're going to have the conservator do those. The investment accounts, where we've got all the investments, because that is beyond their capacity at the time. Conservatorships make a lot more sense, in my opinion, as how to limit them. But limiting the authority of a guardian to make medical decisions, I still haven't figured that one out. In the case I just did, the guardian has the rights to make the decisions about medical treatment. Because I can't figure out how to say, well, for these particular things like flu shots, the person makes the decision, and for these more difficult ones, it's the guardian. How do you? I don't know how to do that so that a doctor or a hospital is going to actually be able to make it work. So
Tricky.
But we're going to be doing more of those because I think that's where the Virginia General Assembly is pushing us. They're not saying it specifically, but in some cases now, I think we're going to be doing more limited guardianships. So other changes from 2023, there's periodic review hearings. So courts are supposed to set up a schedule of review hearings. First one's supposed to be in a year, and then it can be up to every 3 years later to review whether a guardianship's still needed, whether the guardians are supposed to be doing what they're supposed to be doing, and so forth. That can be waived. And in most of my cases, especially when it's parents for an adult child with a disability, the judges are waiving it. If your child's on the autism spectrum, has cerebral palsy, or has Down syndrome, or a whole host of the gene duplication or gene deletion syndromes, unfortunately, if they need a guardianship at 18, they're going to need it at 19, they're going to need it at 20. Some may progress to the point where they can have some of their rights restored. Some may even be able to have all their rights restored, because you can do that. But the need for a periodic review hearing is just over and above in those cases. Now, guardians, there's a process now. If they need to restrict visitation, there's a specific process basically, and entails notifying the person, giving them a copy of the form, sending a copy to the court, sending a copy to the local Department of Social Services that says why, and they have the ability to contest that. And now there's also a requirement for guardians for required visitation. None of my clients, this is not an issue for all of them. They all look at me funny when I talk about it, because parents of adult child, of course they visit. First of all, most of the time they live with the person, but even if their son or daughter's in a group home or in a sponsored residential setting, they visit all the time. So that's not an issue typically. Duties of a guardian. So the primary decisions that a guardian makes for a person are, well, the primary duty is to make decisions in the person's best interest. In addition, they have the requirement to file an annual report. It's 4 pages, really 3 pages of questions. How's the person doing? How many times have they been to the doctor? Has their condition changed any? Do they need a guardian still? And it's really straightforward. And there's a $5 filing fee to that. Other than that, there really isn't any other duties specific for the guardian. They're not liable for the acts of the incapacitated person unless the guardian is personally negligent. There's no case law that says what means negligence, what equals negligence in this case, but my example is that if you take your son or daughter to the grocery store and there's an incident where they hurt somebody or damage property, it's probably going to be, you're going to not have any issues the first time you do it. Second time, probably not. But if you're there 3, 4, 5, you keep doing the same thing and the same thing's happening, then at some point there's probably some negligence. But like I said, I don't have any clients where this is an issue, nor do I expect to ever have an issue with that. And a guardian is not required to spend their own funds on behalf of a person. So think of it this way. Parents often believe that to be the case because as a parent of a child under the age of 18, there is a legal requirement to be paying for them to, what is it called for Medicaid even? It's called, oh shoot, I'm going to draw a blank to this. But at age 18, even under a guardianship for an adult, the guardian is not responsible for paying for the person's needs. And more than that, guardians aren't actually required to provide personal care. Guardian's job is to make decisions for a person, so they don't have to live with them. And the reason I bring that up specifically here is that for most guardians, when it's a parent of adult child, that's really not an issue. But when we talk about who's going to be a guardian after the parents pass away, because we can ask the court to appoint a standby guardian, which somebody who does nothing while the guardians are living, but steps into their shoes after they pass or when they can no longer carry out the duties of a guardian. And for standby guardian, then we're sometimes talking aunts, uncles, but further down the road, we're talking about siblings, perhaps, or cousins. And when we talk to them, really should make clear to them is that we're not talking about having to live with the person. Sometimes that's a lot of care, even with attendance through waiver service and so forth. But they just need to be available to make the decisions for them. And I guess the last thing I'd want to say about all this is no matter whether you do a power of attorney or you go the guardianship route, it really does not change how we work with our kids with disabilities. You're still going to talk to them and try to get them to understand what's going on to the extent that you can, to the extent that they can understand. You're still going to include them in decision making to the extent that they can. Doesn't change any of that. What it really does is in either way, we get a piece of paper that we can give to a third party that says to a doctor or case manager said, this is why I get to do certain things, either make the decisions or help make the decisions and do things so that they can put it on file and allow us to do that. Okay, so it's 2:45 and I'll go for another 10-15 minutes. I can get the rest in. If you have questions, go ahead and I think everybody who's already probably submitting them already answered one, so I'm not going to stop here for questions. So disability benefits, we'll talk about SSI, SSDI, and this is actually wrong now. It's disabled adult child benefit. I didn't change it here, but I changed it on the other slides. We'll talk about that in a second. And healthcare for Medicare and Medicaid. There's ways that our children can get various ways can get many of these benefits. So SSI is supplemental security income. It's meant to help persons who are blind, disabled, or over the age of 65 that have low assets and low income. And this is the benefit that typically a young adult, when they're turning 18, will become eligible for. Now, most are not eligible prior to the age of 18 because their parents' income and assets are deemed to be theirs. Remember I said it's expected that parents financially provide for minor children. Well, that parental deeming of income and assets ends when the person turns 18. And it's just their income, just their assets at that point. And then typically they become eligible for SSI. The maximum benefit for SSI is $943 a month, so it's not a lot. It's meant to pay for living arrangements. This is another change recently. The Social Security Administration is no longer considering the payment of food payments from a third party as in-kind support and maintenance. So that's a good thing. Haven't really figured out how that's going to change stuff. And when I do, I'll let people know. SSI has a $2,000 countable resource limit. And so you want to make sure then at the end of every month that your child has less than $2,000 in all of their various bank accounts. Typically, I actually just recommend that they have one, the representative payee account. And that way, my fear is that if you have multiple accounts that you'll forget to add them all up, and there'll be months where you might be over the $2,000 limit. Social Security Administration is not going to catch that on a monthly basis. They don't look at it that way, but they do audits. And so several years after the effect, I picture this person in a dark room in the basement of some building, and with a little light hanging from them and with a yellow marker going over the limit, over the limit, over the limit. There's nothing you can do at that point. So $2,000 countable resource limit is a hard and fast limit right now. I've probably heard that you want to charge your son or daughter when they're receiving SSI for their fair share of living arrangement, housing expenses, and you do, because if they're living in your house and not paying their fair share, then that's a type of unearned income called in-kind support and maintenance, and if the 1/3 reduction rule kicks in. SSI, Medicaid have all these stupid little rules that we've been saddled with. So once you do charge them for room and board, well, for room now, then their fair share of living expenses, then Social Security Administration will pay the max $943 benefit. Final thing on SSI is that when they work, if your son or daughter is able to work and they're receiving earned income, you'll need to report that to the Social Security Administration. It will reduce their SSI, but not on a dollar for dollar basis. There's work incentives that apply to reduce the effect. And the takeaway that I'd like you to have from this is that your son or daughter will always make more money working, even though their SSI is reduced. If you're worried about whether or not they're going to be making too much money, that's great. Actually, that means they're doing really well. The number to look at then is this SGA income limit. Right now in 2024, it's $1,550 a month. And I say the time to really start thinking about it is about the time they're making $1,000 a month on a regular basis, because there's more work incentives that'll apply. In fact, using something like the ticket to work, which is not part of this presentation, puts them into contact with an employment network. They can get a specialist that will help guide you at that point, and the government pays for that. So anyway, always make more money working, even though SSI is reduced.
What does SGA stand for?
Substantial gainful activity. It's a defined term. It's rolled into the definition of disabled for SSI and for SSDI. And so to be disabled, it's not that you can't work at all, it's that you can't perform substantial gainful activity. You can't make enough money to support yourself. And one measure of substantial gainful activity is $1,550 a month. If you're making more than that, you're likely not going to be approved for benefits, even if you are really disabled. So, SSDI. So what is this? Similar acronym. It's managed by the Social Security Administration, completely different than SSI. Not completely. It's the same application process. In fact, when you apply for disability benefits, they always look first to see if SSDI, if the person's eligible for SSDI before they even look for SSI. And it's the same medical requirements, but SSDI, Social Security Disability Insurance, is a Social Security benefit as part of the Social Security Act. We pay for it when we work, and it's through our payroll taxes. And why is this on here? Well, there are some young men and women who are getting SSI that are working. great, they always make more money doing that. But after about 4.5 years of, actually quite minimal part-time work, they may be eligible for SSDI off of their own work record. And that's a good thing. Now, it doesn't result in any more money to them, because if they start receiving SSDI, their SSI is going to be reduced on a dollar for dollar basis, but it comes with Medicare. Take a look at that in a little bit. And SSDI, the more they work, the more they get of SSDI, the less SSI. SSDI doesn't have all those stupid little rules that are set at SSI is saddled with, nor does Medicare. And the other one that they can get is a disabled adult child benefit. This is when a child with a disability who is disabled before the age of 22 and is still unmarried, when a parent retires and starts drawing Social Security, or that parent becomes disabled and starts drawing SSDI, or the parent passes away. Let's go with the first one, when they retire, because that's the fun one. Their child can start drawing a disability benefit off the parent's work record. It's often known as SSDI off of a parent's work record. This is a lot like that. And it can vary how much. It depends on the parent's work record. So I have some clients who get SSI and SSDI off of the parent's work record. But in many cases, when the parent has a more substantial work record, that can be $1,400 to $1,800 a month. And then when the parent finally passes, because there's a family cap of how many people drawing off of one wage earner's work record, it can go up to like $2,400 a month. It's a lot more than SSI. It wipes SSI out at that point, but we don't care because it's more money. And it also comes with Medicare. So this is kind of the way it looks. These are actual numbers. SSI only 943. SSI and part-time work, again, always make more money. If they're able to work, then eventually they'll get this SSDI off of their own work record. And as the more they work, the more this goes, more of this part grows, and the more the SSI will be reduced. And then eventually then, if they're still eligible for benefits, they'll have their part-time work. Oh, I'm sorry, here it's the SSDI and this is SSI. And they'll have their part-time work and the disabled adult child benefit. This is a real sweet spot where, if possible, I like to try to get most of my clients eventually. Some clients, their son or daughters aren't going to be able to work. That's okay. They'll get SSI until they get to this. So Medicaid can be seen as like a companion to SSI. It's a joint federal and state program managed by the states now. That is for persons with disabilities or blindness or over the age of 65 that have low income and low assets. The asset limit is the same. It's $2,000. The income limits vary. So the income limits are different. They're higher, less chance of losing your Medicaid and losing your SSI. But either way, there are work incentives that would help reduce the chances of losing benefits. So Medicaid isn't necessarily all that good. It's not even insurance. It's a payment program, and it's always the payer of last resort. And really, Medicaid's important, though. I'm not saying it isn't. And it is actually the only benefit right now that pays for long-term nursing care. Medicare doesn't pay for that. Medicare pays for the type of care you need to recover from an injury. You go for rehab. It can be a couple days in rehab. Then more and more, it's a lot of rehab at home. But Medicaid is important, and it's most of my clients have it. Medicare, like I said, the way that an adult child can get Medicare is either by working and getting SSDI, and then they become eligible for Medicare, or when a parent retires and starts drawing Social Security, and the child gets the disabled adult child benefit and also Medicare. The hierarchy of payment is as long as they have private insurance, the private insurance is almost always gonna pay first, then it's Medicare, then it's Medicaid. There's actually a fourth one in here for any military families. It's TRICARE, and TRICARE falls in right here between Medicare and Medicaid. Well, actually kind of, if that's the right spot for it, TRICARE. Because if a person gets both TRICARE and Medicare, Medicare is going to pay. If it's just TRICARE, if the hospitals only takes TRICARE, then it's TRICARE. Was there a question? I'm sorry. Okay. And last but not least, so SSI, Medicaid, Medicaid waiver services all have a $2,000 countable resource limit. Eventually, young adults that get that disabled adult child benefit and Medicare, well, disabled adult child benefit and Medicare don't have asset limits. Like I said, a lot of the stupid little rules that SSI and Medicaid are saddled with go away at that point. But most are still going to be dependent on Medicaid waiver services, which are really important. That's the part of the Medicaid long-term care program, not just nursing care, nursing homes, but then there's the waiver services for supports for young adults or adults with disabilities to live and work in the community as independently as possible. And they are really essential. And that has a $2,000 countable resource limit. So for parents or family members to be able to leave an inheritance to a family member that's receiving SSI, Medicaid, Medicaid waiver services, they can do that by creating a third-party special needs trust. Money in a third-party special needs trust doesn't count for eligibility purposes for those benefits. Why? Because it's not the person's, it's the trust. The trust is a separate legal entity, it gets its own tax ID number, and it's the trust. Now, the person with a disability is the sole beneficiary. The money in the trust has to be used for their benefit, but it's not theirs, so it doesn't count as against their eligibility for those benefits. So we have a trust for our daughter, and typically a third-party special needs trust is not funded while you're living. It sits as an empty bucket waiting to be filled, and its purpose at that point is to protect eligibility for benefits. It's filled after you pass through wills and beneficiary designations on things like life insurance, IRAs, 401ks. And so my beneficiary designations in my will, I'll say everything to my wife. She's my primary beneficiary. And if she's no longer living, then half to my son is typically developing and the other half to my daughter's trust. So it doesn't go to her directly, it goes into her trust. And the successor trustee manages that money, invests it, but uses it to supplement her income and her disability benefits and improve her quality of life. And I can tell you, it does bring me quite a bit of solace, so that when we have ups and downs in life, I typically, when something happens to my daughter, like she loses her job, my first reaction is like, oh my God, well, what would happen if we weren't here? Well, we have a trust. There would be money. There'd be a trustee. There would be people that can help her at that point. So the trust from a financial standpoint then reduces my anxiety, because I know there will be money there to help her when that time comes. Trusts can own anything that a person can own. So it can even own real estate. So in some cases, a third-party trust can be a way to, can play a part in when you're determining what your son or daughter's long-term living arrangements are going to be. You own a home that's perfect for them, you got attendants in there, and you got it all set up for another family member if they need it, or if they're more capable of living on their own, and you want to make sure that home is available for them because it's perfect. Well, then you can make sure it gets into their third-party special needs trust. That way, it doesn't count as a resource. There's no Medicaid kind of payback liens. Any money in a third-party trust, when the beneficiary passes, goes back to the, no, does not go back to the state. It goes to whomever you say it does in the trust agreement. And so that way you can make sure, if you wanted to leave your home to a third-party trust. It can own a car that's used primarily for the individual if they need specialized transportation. So there's lots of things you can do with third-party trust. And I think every family that has a child with a disability really needs one. You can either do it with an attorney where the attorney writes it and helps you set it all up, or you can do it through the Arc of Northern Virginia or Commonwealth Community Trust through a pooled trust. Those are really good opportunities as well. First party trust, we can get more information on these, but I'm only going to say for this presentation is this is the kind of trust we want to avoid. This is the kind of trust I have to do when a person gets a direct inheritance or when there's an injury settlement. Remember, I talk about sometimes we have to do a conservatorship just to be able to create one of these. Because this has a Medicaid payback clause. Any money left in a first party trust when the beneficiary passes first has to reimburse the state for Medicaid expenditures on that person's behalf. So we try to avoid this one if at all possible. And I already talked a little bit about pooled special needs trust. Commonwealth Community Trust and the Arc of Northern Virginia both do third party trust and first party trust. I think they might call it like family funded trust. That's their ARC's version of a third party special needs trust. So these are also really good organizations and opportunities for people looking in doing trusts, especially if you don't have a whole lot of family members that are available or will be available to be successor trustees. What else do I have down here? Oh, able accounts. I'll cover it really quick. So able accounts were originally conceived as a way to do a less expensive way for persons to save money instead of doing trusts. It didn't quite get there, but they're still really good. Money in an able account does not count as a resource for SSI, Medicaid, and Medicaid waiver services. There is an $18,000 annual contribution limit, so it really can't take the place of a trust because you can't name it as a beneficiary of like life insurance and wills either. It does have a Medicaid payback clause. State of Virginia said they're not going to do that to the extent federal law allows. Federal law still requirements. So my best guess is that if there's a limited amount of money when the person dies many years from now, that the state's probably not going to make a large effort to collect that. If there's a lot of money though, I can't put it past the state to say, DMAS to say, well, federal law still requires it. So my advice with an able account is if you need one, open it. They're great. It's a great place for the disabled person's money. It's a super savings account for them. So they can get over that $2,000 accountable resource limit and be able to spend some of their money and have access to it. And it's also a great place. So if they get a direct inheritance from a long lost uncle and it's $20,000, I can tell you absolutely that my advice, because I've done it before, is to open an able account, put $18,000 in it and spend the other $2,000 on non-countable resources like new clothes and furniture and things like that. So they're really, really good accounts. And that would be it. I think I came in just under an hour.
You did. Wow. That was, I know, and everybody here is like, that is a ton of information. And I can't thank you enough, Matt. Like I said at the beginning, for staying up on all this and really being able to explain it in a way that is understandable. And, but these are like some of those core issues that really, pretty much everybody has a question with, and at some point in time. And so I'm just so grateful that you're there as a resource for us and for our families. So thank you guys for joining us. Are there any last minute questions